Hillary Clinton responding to written questions from Judicial Watch as part of a major lawsuit regarding her use of a private email server. The newly released documents show she replied, "I do not recall," many times, including when she was asked if there were specific consultations regarding the decision to use ClintonEmail.com or if she participated in any communications on the decision to use it. She also didn't recall considering factors beyond convenience in the choice to use a personal email account, as well as destroying or disclosing emails on official State Department business. In total, she used some variation of the phrase "do not recall" at least 20 times in response to those 25 questions. Chris Farrell is Director of Research and Investigations for Judicial Watch. Chris, this has been an effort on your part for a long time, and your organization's part. Did we learn anything new from those questions that she ultimately answered, first of all?
Hi, Sandra. Yes, we did learn something new. First of all, that Mrs. Clinton is at best misleading and at worst lying to the court, right? She has developed this sudden case of amnesia concerning all sorts of documents, all sorts of things that she's signed and implemented, things like non-disclosure agreements, security briefings that she's received, and suddenly she can't recall any of these details. She's stuck. If she's not going to perjure herself, and she's not going to make admissions against her own interest.
Okay, so as expected, she played it safe. But did you expect that? She said she cannot recall in some form 21 times. There was only 25 questions. So was it your sense that she was really trying to answer these questions because her camp maintains this is the same old thing we've answered a million times?
Yeah, this is utterly unbelievable. It's the legal handiwork of David Kendall. I think when Judge Emmett Sullivan reads this answer, who was appointed to the bench by Mrs. Clinton's husband, and he's the federal judge who authorized us to conduct our investigation of this matter, I don't think Judge Sullivan's going to be terribly persuaded by this sudden, wide, selective amnesia.
So as far as that amnesia is concerned, going back to an FBI report, when the FBI interviewed Clinton, investigators did report back then that in December of 2012, Clinton suffered a concussion and then around the new year had a blood clot. Based on her doctor's advice, she could only work at State for a few hours a day and could not recall every briefing she received. An excuse?
If she's incapacitated in some way, then I think it's incumbent upon her to make a full disclosure about that. The important thing in our case is the FBI did not even get her under oath. We did. And so now we have sworn statements of what her position is and what she says she can or cannot remember. It's utterly unbelievable, and what it does confirm is that she placed the United States in grave danger because there's still those 22 top secret emails that went across her server that the Inspector General of the intelligence community identified. She endangered the United States, and now she's lying about it.
And by the way, it wasn't just the 21 do not recalls. In addition to that, she entered various legal obligations to the formation or wording of 18 of the 25 questions, and she also filed 8 separate general objections to the process under which the questions were being asked. It appears to be an effort to really not get Ms. Clinton into any more trouble by answering these questions.
It's the worst sort of lawyering that makes people hate lawyers.
Had it been much different had this been verbal?
If it was in person, if it was live testimony, yes. The fact that we were put in a position where we could only rely on interrogatories is a disadvantage. In fact, that's why even in arguing this, the judge himself, Judge Sullivan, wanted us to argue it in person in front of him.
Yeah, and her camp, Brian Fallon, saying that these are the same questions that she has personally and verbally answered aloud.
And she never has, and not under oath. We're the only ones who have ever gotten her under oath.
Chris Farrell, thank you, sir.
Thank you.
All right, we are...